The first case to come before us this morning is State of Ohio versus Christian Martinez. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve any time, please let me know when you get started. I'm keeping the clock, and I can let you know when you're getting close to or into any reserved time. Please don't use the names of victims or minors, as we are being live streamed, and this is being recorded and will be placed on our YouTube channel. We have read the briefs and we are ready to proceed when you are.
All right, thank you, Your Honor. Counsel, I represent Christian Martinez in this matter. Christian was charged with very serious charges, as this court knows, and he pled to an attempted murder charge. What happened in this case, and the reason why the court maxed him out on the sentence, was because my client did not give on the record an explanation for why he did what he did. He apologized on the record. He indicated that he was sorry, that he indicated to the victim, who gave a statement in court, that he was very sorry about her suffering, and her suffering is undisputed in this case, and that's not undisputed. What is the dispute is that because my client did not give an explanation, my client got maxed out with the maximum penalty. We're talking about somebody who's my client, who has absolutely no criminal record whatsoever. He's never even been in the criminal system. There was no evidence that he'd ever been in the juvenile system. There was no evidence that he had ever been involved in anything like this. And of course, he never had a criminal crime. And so when the court decided to max him out, that was, I considered, a cross the line in terms of my client's Fifth Right Amendment, because at that time, my client they're forcing him to explain something. In certain situations, Your Honor, with everything live tube as it is, everything is on the internet as it is, certain situations, people may not, at least on my side of the fence, people may not be wanting to give explanation for why things occurred or who, or stuff of that nature. And I believe that in this situation, my client's rights were violated, and he was given a sentence, the maximum sentence, when he should not have. I'm not contesting the consecutiveness with the weapons that comes with it, on anything he would have gotten. But I'm saying that the 11 years is improper, unlawful, and an abuse of discretion, Your Honor.
Counsel, I just want to, I'm sorry.
Go ahead,
Judge, you want to proceed? Okay. I just wanted to double check here. So my understanding is the reason why the judge was trying to get an understanding of what happened was because he went up to a random car and shot the victim 6 times. And so I guess what I'm wondering is, yes, the trial court may have asked a little bit about that, because that may have entered into some kind of mitigation or whatever. But regardless of what he didn't or didn't say, that was definitely probably the worst form of the offense that you can think of, isn't it?
Yes, Your Honor, I think it is. And I'm not disputing that. I think that does speak for itself in terms of what he did. But what the issue I have with this case is that there is a balancing requirement. There is an obligation that the court consider certain things in terms of, not the law used to be that because with first-time offenders, there used to be some law that controlled that, and it was better, I believe, after me. But no, there's still a requirement that when individuals are on sentencing, that they're not obligated in any way, shape, or form to violate their Fifth Amendment right, or to explain or give reasons for what occurred when that's not the issue. The issue, we know what occurred. The question is whether or not my client can be rehabilitated. And that's what happened in this case, because the court decided that my client was not giving an answer that they considered appropriate or explained enough. They decided my client was not not subject to rehabilitation. That's wrong. That is when sentencing was wrong. And my client has no record. There's no indication. It was a bad offense. I'm not saying it wasn't, but I'm saying that it doesn't have it. The test is not, yeah, this is just a bad worst offense, and that's the only inquiry. That's not it. My client could have been subject to rehabilitation. With this type of sentence, he's going to be doing some time.
Counsel.
Yeah, go ahead.
Was there a pre-sentence investigation done?
Yes, Your Honor.
I'm not sure that's in the record, counsel.
Okay.
Judge Carr, I'm sorry to interrupt you.
No. I'm just trying to understand. I guess what I'm wondering is, again, this was in obviously the range of sentencing. And when somebody shoots somebody 6 times, it's clear they mean to kill them. And, I guess my thing is with this appellant, he is pretty lucky that the victim didn't die. Or you talk about some time he was spent in jail. So I guess, again, I go back to, do you think this really implicated the judge's decision as to sentence him to a maximum term?
Yes, Your Honor, I do. I think that it does implicate that. The issue is every single case that is the most serious type of offense that occurs does not always warrant maximum time. If that was the law, then it would be in the law. It's not the law. And so as these cases get worse, and this case is worse, that doesn't mean that means that the automatic situation is that my client should get the max. And that's what I'm arguing, that because my client refused to give an explanation of why, and basically for whatever reasons, he got maxed out.
Counsel, would you wish to proceed or reserve for 5 minutes of rebuttal time at this point?
I'd like to reserve, Your Honor, if I could.
Certainly. Counsel for the state?
Your Honors, Lindsay Paprocki of the Lorain County Prosecutor's Office on behalf of the appellate state of Ohio. This appeal is solely based on appellant's complaint about his this term of his prison sentence. This sentence must be placed in context. A senseless random act of gun violence gave rise to the charges against Martinez. On a winter day in 2018, Martinez shot a woman 6 times at close range as she sat in her car at lunchtime. Seemingly selected at random, the woman, who seconds before the attack had been speaking on the telephone with her elderly mother, survived. At the sentencing hearing, the woman, rather than describing herself as a victim, addressed the court with what she termed a survivor impact statement, in which she described the drastic ramifications that the shooting has caused her to endure. Based in large part on the random nature of the offense, the state requested a maximum sentence be imposed upon Martinez. The trial court also heard from counsel for Martinez before turning to Martinez himself, who, after apologizing for his actions, which he quickly termed a mistake, repeatedly refused to provide an explanation or motive for approaching and ambushing and shooting an innocent woman multiple times, although his counsel had previously indicated that any explanation that Martinez might offer would be extremely insufficient and extremely unwarranted. As a result, the trial court decided that the maximum sentence of 11 years in prison was appropriate in light of the fact that there was an innocent victim of gun violence, that the shooting seemingly occurred at random, and that Martinez fired multiple shots at the victim. Those facts the trial court pronounced constituted the worst form of the offense of attempted murder. Martinez now takes issue with that sentence and contends that the 11-year prison term, the maximum length the trial court could impose on the attempted murder court. In his brief, he contends that that sentence was contrary to the seriousness and recidivism factors set out in RC 2929.112. As this court is aware, it may only vacate a sentence if it determines by clear and convincing evidence that the record does not support a trial court's findings under relevant statutes or that the sentence is otherwise contrary to law. Here, the state submits that Martinez's sentence is not contrary to law and that he cannot provide evidence in the record that his sentence for attempted murder was contrary to law. First, trial courts have full discretion to impose a sentence that is within the statutory range. And Martinez does not dispute that the 11-year prison term that the trial court imposed on the attempted murder count, a felony of the first degree, is outside the statutory range. And he fails, and he never even asserts that the trial court failed to consider the purposes and principles of sentencing or the seriousness and recidivism factors set out in the statute. And he cannot do so because the sentencing transcript from the hearing and the journal entry reflects that the trial court did so. Instead, what Martinez seeks to do here is have this court reweigh and reassess the seriousness and recidivism factors that the trial court already weighed. This court, however, is prohibited from doing so. The Ohio Supreme Court recently set forth that 2953.08G does not provide a basis for an appellate court to modify or vacate a sentence based on its view that a sentence is not supported by the record under the statutory provisions of 2929.11 or 12. Specifically, an appellate court is not permitted to independently weigh the evidence in the record and support its judgment, substitute its judgment, for that of the trial court concerning the propriety of a sentence that best reflects compliance with those provisions. It does not have the power to reweigh those factors, therefore. Finally, as to Martinez's argument grounded in the Fifth Amendment, the state would submit that Martinez never invoked his Fifth Amendment right against self-incrimination during the sentencing hearing. The trial court, therefore, cannot penalize Martinez for exercising a right he did not, in fact, exercise. Having failed to raise the issue, Martinez forfeited the right to raise the constitutional issue on appeal without arguing plain error. Here, Martinez does not put forth a plain error analysis on appeal, and this court should fail to develop one on his behalf. Moreover, failure to provide an explanation for his actions went to the lack of remorse element, which the trial court can consider as a seriousness and recidivism factor, and this court, according to State v. Jones, the Ohio Supreme Court case, cannot reweigh the trial court's determination as to that factor. I would also note that the pre-sentencing investigation report that the trial court did reference several times has not been made a part of the record. And for that reason as well, this court can presume regularity of the proceedings. Ultimately, the state submits that the trial court imposed a stern but richly deserved and, most importantly, patently legal prison sentence upon Martinez, and ask this court to affirm the trial court's sentence and judgment. Thank you, Your Honors.
Thank you, counsel. Mr. Johnston, you will have 5 minutes for rebuttal. And you are on mute.
Thank you. Your Honor, with respect to the issue of my client giving an explanation or not giving an explanation about what he did at the time, that is an an unconstitutional requirement of my client to give an explanation. That doesn't go to anything but, and it's dangerous for my client. It's dangerous for other people. Everything is streamed. So I don't believe my client is required to give an explanation. I don't think the fact that he didn't give an explanation should have been considered. And I don't think that the sentence is appropriate. Thank you.
Thank you, both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which we mail to all sides of this appeal, as well as posted on the Ohio Supreme Court website. Our next video oral argument is scheduled for March the 1st. We are adjourned. Have a good day.